When you suffer harm, you may go to the police. The police also can prevent damage. However, once you have suffered harm, the situation changes. You may know who caused it, in which case you can directly claim that person to repair you. You can even go to the police to come along or intervene in the claim you make to that person. Moreover, you'll likely go to the police when you don't know who caused you the harm to do something to make up for your damage. But finally, the government branch mandated to solve the problem is the justice system. Hence, it's justice, and justice alone, the only one established to, first, determine the identity of the person who caused the harm. This means finding the causal relationship between the action or omission of someone and your damage. But second, it's the only one that can demand or force a person to repair you. What is even clearer is that it's only the justice system, the one established to punish the person responsible, in case punishment is provided by law, depending on the damage, as well as on the type of action or omission of the originator. That is why when we understand security as the absence of harm, the role of justice is vital, and justice governance is concerned with two fundamental things: everyone's access to it, and its effectiveness. In terms of access to justice, a first step that governance must take is understanding why people resort to the justice system. This means understanding society's litigiousness. This is the degree to which society uses its justice system to resolve its conflicts and get the damages repaired. If every harm an individual suffers must be brought into a formal justice agency, not even the most efficient judicial system in the world will be able to respond and give access to its citizens. Several countries have assessed their degree of litigiousness. However, we don't have a homogeneous and standardized measurement of the issue. Therefore, we invite you to review some of the cases that are examined about the countries that have measured their litigiousness in the governance book. But beyond acting on litigiousness, the challenge of justice governance is to give citizens access to the formal justice system. It's clear that we would like the damage not to occur, but once it has been caused, what victims need is reparation, and, eventually, it would give them more peace of mind to see that whoever caused the harm was punished. At the least, we expect in modern society to have someone official to listen to our case and try to solve it, even if we don't get any reparation in the end. That's why access is so important. The United Nations Development Programme has been involved a little in the issue and has asked countries to move forward in establishing an indicator that measures the level of unmet legal needs. Several countries have done that task, and, in the book, again, several of those efforts are examined. However, we also don't have a global and standardized indicator that allows us to know the level of access to justice in different countries. In addition to access, the second issue is the very effectiveness of justice. This means its actual ability to find the person responsible for the damage, urge them to repair it, and eventually punish them. This effectiveness is also fundamental in the governance of justice and, of course, in achieving security. Behind this aspiration, there is a complex problem because the alleged person responsible for the damage, who is under investigation, must have guarantees and rights when investigated. These guarantees are known as due process. Therefore, it's not only a question of a justice system establishing and allocating responsibilities around someone's damage as quickly as possible and accusing a large number of people, because that leads, on the contrary, to a very unjust system. Therefore, justice governance must achieve a healthy balance between the due process, the respect for the guarantees we all have, and its real capacity to produce a result. This means establishing responsibility and commanding the perpetrator to repair. In addition to finding perpetrators and forcing them to repair, justice is also in charge of punishing the person responsible for the harm. A balance must also be reached between harm and punishment. It's not that in the face of any damage, the justice response is imprisonment or huge compensations that put every right of the perpetrator at risk. And there are many types of punishments. For instance, those who breach a contract could pay a fine, as well as those who act with negligence, recklessness, or incompetence. Similarly, those who fail to comply with an institutional duty may be subject to a disciplinary sanction. The doctor may end up with his or her medical license suspended or revoked. The public servant may be barred from holding public office, etc. The one that undoubtedly generates the most governance interest is imprisonment, which means the arrest of the individual responsible for the damage. Prisons or the penitentiary system must fulfill three functions. First, of course, to punish, but also, through punishment, send a message to deter the potential criminal. to make the criminal's cost-benefit relation more expensive. But the third goal that the prison system must fulfill is resocialization, and it's perhaps the one where it fails the most. One of the questions facing prison systems is whether jail is helping to lower crime. The evidence says that very little. There are countries with an equal level of crime, but with very different detention rates, even at the same level of perceived prosperity. The other problem is that there is abuse in the prison system of preventive detention. When a person is being investigated as to whether or not he or she is responsible for a damage with criminal incidents, in many cases, justice can arrest the individual preventively or cautiously while being investigated and during trial. These preventive detentions have become the cause of a large number of inmates, with certain countries in which about half of its prison population has only a preventive measure and not a final sentence. Prison systems have another problem: overcrowding. Several countries suffer this anomaly, which means that there is a violation of the rights of detainees, but also that prisons become actual schools of crime. The United Nations has adopted parameters known as the Tokyo Rules. They encourage countries to seek alternative penalties other than imprisonment, among other reasons, because it's costly for everyone, especially for the criminal and his or her family. Unfortunately, the reality is that justice fails big in this regard. In practice, the prison system functions as some sort of landfill for human beings, and resocialization seldom occurs. A final element of punishment is when the perpetrator of the harm is a minor, and it has criminal incidents. The governance of justice invites to treat this case in a very particular way, and resocialization becomes even more critical. In fact, many countries don't deal with these cases as criminal law, and, therefore, the penitentiary system is not involved. Moreover, since the alleged immaturity of the minor doesn't make him responsible for the action, the consequence of establishing causality between his act and the damage doesn't produce punishment. On the contrary, this situation is considered a danger for the minor. The Index of Economic Freedom includes a subcomponent that measures judicial effectiveness and assesses it by evaluating three elements. First, judicial independence; second, the quality of the judicial process; and third, the favoritism of judicial decisions. Meanwhile, the World Bank has another well-known series of indicators called Doing Business. It rates countries regarding their conditions to do business. Within that series, an indicator also evaluates the performance of justice, measuring its capacity to enforce contracts. Both Heritage's and the World Bank's indicators are measured from 0 to 100. The graph shows the results for our selection of countries of the Heritage's indicator of judicial effectiveness. At the top, we find Singapore with a score of 91. The global average is 46. The best judicial performance is found in countries perceived as prosperous, such as Australia, Norway, and Switzerland. On the contrary, both sub-Saharan and Latin American countries appear in the last places. Looking specifically at the regional figures, the OECD countries and those of the European Union have the best judicial performance. When we look at the global average of the World Bank's Enforcing Contracts indicator, we have a time series of almost 2 decades, in which it's evident that justice performance hasn't really changed in all this time, remaining around 56, which is not necessarily good news. First, because from the outset the level is not very desirable, and, second, because the situation isn't changing enough.